SwayamPrabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. Today, I am going to discuss role of prison in safeguarding human rights. So, in this lecture, I would like to highlight statutory provisions as well as constitutional provisions, where prison authorities are supposed to protect human rights of the prisoner, be it under trial prisoners or convict prisoners. As per the statutory provisions, prison authorities are bound to provide basic amenities, basic rights provided by the statute. So, let us try to understand the meaning of prison, and then after I would like to highlight two different approaches, two different views on prison authorities. So, with the help of this slide, I would like to throw some light on prison authorities. You just look at your screen. You may have some idea about prison. Prison being important component of criminal justice system is under obligation to protect rights of the inmates of prison. Statute, you all might be aware, there is century old Prison Act 1894. You can see this prison, section 3 of this Prison Act 1894. There are two different views. Prison as a place of rehabilitation, that is the approach of reformative theory. Another important theory of punishment, that is known as retributive theory of punishment. According to that theory, prison is considered as a place of punishment. So, with the help of these two important views, we will try to understand whether prison should be treated as a place of punishment or prison should be treated as place of rehabilitation or place of reformation. And section 3 of this Prison Act is important. Section 3 of this Prison Act defines prison. So, now come to the meaning of prison. According to section 3 of the Prison Act 1894, prison means and includes any building which is used permanently or for temporary purposes to confine accused or under trial prisoners. So, here you can see that section 3 of this statute makes it clear that any place or any building which is used for confinement of accused temporarily or for permanent purposes, that place may be considered as prison within meaning of section 3 of this act. Meaning thereby, even a temporary, any place can be converted, any private building can be converted into prison for temporary purpose. You might have seen that during the period of any agitation or strike, when people who are involved in agitation or in strike, and if they will create any kind of problem to the government, to the state, then state can arrest them and state authorities can arrest them, and state authorities can put those people in a particular place. Because you see, each and every district has prison, but prison has very limited capacity, and people who are involved in agitation or strike against the government, if they are put in that prison which has very limited capacity, it would create problem for other prisoners who are already in prison. So, state governments can use any private building for confinement of those people who are creating disturbance against the government for a temporary period, for specific period for say for 1 week or for 1 month. So, any building or any institution can be converted into prison for a specific period for temporary purposes. So, this place section 3 is very wide, it has covered permanent building or temporary building which can also be converted into prison. Now, come to this another aspect of prison system, how prison should be considered as a place of rehabilitation and why prison should be considered as a place of punishment. It depends upon two important theories of punishment. One is rehabilitative theory, reformation theory. So, according to reformation theory of punishment, prison should be considered as a place of rehabilitation, as a place of reformation, where offenders have committed crime knowingly or unknowingly or under compulsion. If they are kept behind the bar, that place should be considered as a place of rehabilitation. According to this theory, those offenders who have committed crime, they should be given opportunity to repent themselves. They are given opportunity to repent their act, their deed which they have committed against the government, where they have breached the law. So, they must be given opportunity so that they can repent, they can be brought into the mainstream of the society. Otherwise, if they would be kept in prison along with hardcore criminals, there might be possibility that they may also become hardcore criminals. So, they give argument, reformative theory, exponent of scholar of this theory, they give rational, they give logic that offender must be given opportunity to repent themselves, and prison should not be considered as a place of punishment. They are human being, though they have committed crime, but they are human being and they are entitled to get all the basic rights, all the human rights which common man can claim, ordinary citizen can claim, except few fundamental freedoms. For example, freedom of speech and expression, freedom of movement from one place to another place. These freedoms cannot be exercised, cannot be availed by those offenders who have been put behind the bar, but except these few freedoms, they are also entitled to have all the human rights, because there is one presumption, that presumption of innocence. Every person is presumed to be innocent unless his guilt is proved before the court of law. So, because of that presumption, every person is presumed innocent. They are also entitled to get all the benefits which they can claim, which they would have claimed against the government if they had not committed any crime. So, it means that this theory is more logical. I think it appears that this view is more logical, more rational, reformative theory of punishment, that every person should be given opportunity to repent himself or herself, so that he or she can be brought into the mainstream of the society. So, this is one reformative theory. You might be aware about this theory of punishment. Reformative theory of punishment has always been in favor of giving opportunity to the offender for rehabilitate or to repent their crime, their bad deeds, and this reformative theory of punishment has always been insisting, emphasizing on giving more liberty to the offenders. This prison should not be considered as a place of punishment. So, rehabilitation is paramount concern of this theory. Reformation, they must be reformed, they must be rehabilitated. So, this is the view of reformative theory of punishment. On the other hand, there is another important theory of punishment, that is known as retributive theory of punishment. So, according to retributive theory of punishment, the exponent scholar of retributive theory of punishment, they argue that a person who has committed crime must be punished, and prison should be considered as a place of punishment. No leniency should be given to the offenders. Offenders, they do not deserve any kind of leniency, and government should not give any kind of leniency or exemption to the offenders. So, prison should not be a place of reformation, that place should be treated as place for punishment, and tough action, stern action should be taken against the culprit. Because this theory believes in the ideology, this theory believes in tit for tat. You might be knowing one maxim that Sathe Shatyam Samacharit. So, this theory is based on that principle, that person should be, offender must be taught a lesson, so that he or she cannot repeat the crime. So, this is the view of retributive theory of punishment, and you might be aware about the exponent or scholar of reformative theory of his school, that Justice Krishna Iyer. He was a great supporter of reformative theory of punishment, and to some extent I would not hesitate to consider him founder or father of reformative theory of Indian means Indian context. He is a founder of reformative theory of punishment. He has already been highlighted in his many judgment that bail not jail, bail should be a rule and jail should be an exception. So, in the light of that judicial pronouncement, in the light of that observation, we can say that Justice Krishna Iyer has always been emphasizing that bail is a rule and jail is an exception. In exceptional circumstances, person should be jailed, person should be kept in behind the bar, otherwise more and more offender should be given bail. So, he does not, one thing I want to make it clear that bail not jail, this policy does not mean that offender or hardcore criminal should not be punished. It only means that where offence is punishable with less than 7 years imprisonment, in that offence the policy of the government should not be punish the offender, should not be put the offenders behind the bar. Where offender has committed crime which is punishable with less than 7 years imprisonment, in such kind of offences bail should be a rule and jail should be an exception. So, he observed this, he made this observation in the light of that offence, in the light of non-serious crime. So, in case of non-serious crime, person should be given liberty, person should be given bail, and in exceptional circumstances where person has committed heinous crime, serious crime, then he should be jailed, he should be put behind the bar, he should be kept in jail, prison. So, Justice Krishna Iyer has been emphasizing this theory, and you might be aware that in Moti Ram case, in Moti Ram versus State of MP AIR 1976, I just want to refer this case on your screen. You Moti Ram, if you Moti Ram versus State of MP AIR 1976 Supreme Court. So, Moti Ram case is very leading case on bail principle, where it was observed by Supreme Court that trial court, while granting bail to the accused, should not fix the amount of bail so high, so that accused cannot furnish his bail bond, accused cannot provide that much amount due to poverty or due to financial constraint. So, trial court, while granting bail, should consider the financial status of the accused. So, if the amount of bail bond is so high and accused is poor, he is not in position to pay that much amount. So, it would be injustice by the court. So, trial court, Supreme Court has observed this thing in this case, that trial court while granting bail should consider the financial position, financial condition of the accused. So that so the purpose of bail may be achieved. If the amount of bail is so high, then it would be very difficult for the accused, poor person, poor accused to get bail from the court. So, this is another important aspect of this case which you need to understand, which you need to remember. Now, come to this role of prison. How prison authorities are supposed to provide protect rights of prisoner. With the help of this slide, you can see how prison authorities can protect rights of inmates of prison. Legal aid to the accused who are in prison. Under trial prisoners are entitled to get legal aid, free legal aid, medical aid, medical treatment, and it is the duty of prison authorities to secure safety, custody of inmates of prisoner. It is legal duty of prison authority to provide secure and safe custody to the prisoners. Many times you might have seen that offenders, even offenders are murdered or offenders are killed in prison, either by prison authorities or by offenders. So, many times it has been seen that offenders, they kill their enemy offender in prison. So, even prison jail is not safe for the prisoners or offenders. So, it is the duty of prison authorities to protect rights of prisoners, and where all these things are mentioned, where all these things are provided, that is statute. Statute itself has given liberty to the prison authorities to provide all these things. Food and shelter, section 7 of this act is very important. So, that is why I have highlighted this section 7, Prison Act 1894. So, what section 7 says, I would like to refer sections. According to section 7 of the Prison Act, prison authority, particularly superintendent jail, has to ensure that inmates of the prisoner, under trial prisoners as well as convict prisoners, they are getting food, proper food, or they are getting proper custody. They have got custody, they have got shelter. So, it is the duty of superintendent jail to ensure that the under trial prisoners who are languishing in jail, who have been kept in jail, are getting proper food. If they are sick, if they are suffering from any kind of acute disease. So, it is the legal duty of jail superintendent to provide medical treatment to the under trial prisoners or convict. Section 24 of this statute is very important. Section 24 of the Prison Act 1894 says that it is the duty of jail superintendent to provide medical assistance, medical treatment to those prisoners who are suffering from any chronic disease or any. So, even if any inmates of prison is suffering from psychiatric problems, so it is the duty of jail superintendent to provide such kind of facility in jail. So, all these things are provided in the Prison Act 1894. So, the Prison Act 1894 says that jail means prison authorities, by doing so, by providing all these facilities to the prisoners, can protect rights of the prisoners. So, though they have breached the law, though they have committed crime, but merely because of committing crime, they cannot be deprived from their basic rights. And you all might be aware that they are human being. So, being human being, they are entitled to get all the human rights except few freedoms, as I said. So, now come to another aspect of legal aid to the accused. These are the statutory rights provided in Prison Act 1894. Now, come to other safeguards, other statutory rights, other fundamental rights provided in the Constitution or Supreme Court itself has recognized certain rights as fundamental rights, and Supreme Court has been emphasizing that prisoners, under trial prisoners particularly, they are also entitled to get all the benefits. So, now I would like to refer those constitutional provisions. You might be aware about, you might be knowing Article 22 of the Indian Constitution. Article 22 of the Indian Constitution specifically provides that every arrested person must be produced within 24 hours from the time of arrest. Every arrested person shall have right to be produced within 24 hours to the nearest magistrate from the time of means arrest. So, this kind of protection is given in the Constitution only because of protection of human rights, only because that arrested person soon after the arrest, it is the duty of arresting officer to give information to the authority concerned that arresting officer has police officer, they have arrested someone, and if information regarding arrest would be communicated to the competent authority, to the court, then the chances of atrocities, the chances of fake encounter, the chances of police atrocities would be very less. So, the object behind putting this provision in part 3rd of the Indian Constitution, that every person has right to be produced within 24 hours from the time of arrest to the nearest magistrate. So, this kind of thing is provided in part 3rd of the Indian Constitution as a fundamental right. So, the effect of this provision is that if someone has been arrested by the police officer and police officer, arresting officer has failed to comply this provision, it would be, the detention would be unconstitutional, and once the application is made by aggrieved before the court, High Court or Supreme Court, and if suppose if he has come before the High Court or Supreme Court under Article 32 or 226 for habeas corpus, that his detention was unconstitutional because he was not produced within 24 hours from the time of arrest, and which is violation, gross violation of Article 22 of the Indian Constitution. Once the detention is proved before the court, the time of detention is proved that he was detained for more than 24 hours without judicial notice. So, detention would be unconstitutional, and judiciary will declare that detention unconstitutional because authority is bound to produce every arrested person within 24 hours from the time of arrest. This thing is also another important right of accused is prisoner. Prisoners are also entitled to get legal aid from the government. So, as you might be aware that prisoners are also entitled to get legal assistance. They are entitled to engage counsel of their choice. State cannot compel them to take legal assistance from particular class of advocate or from particular advocates. It would be violation of Article 22 of the Indian Constitution. So, Article 22 of the Indian Constitution gives liberty to every citizen of this country to have advice from a counsel, from advocate of his own choice. So, choice is, so every person is free to take legal advice from advocate, from counsel of his choice. So, it is specifically provided under Article 22 of the Indian Constitution. The similar provision is also given in section 303 of the CRPC. Section 303 CRPC talks about legal aid to the criminals. Accused who is criminal, who has committed crime, is entitled to get legal assistance according to section 303 CRPC. Section 304 CRPC talks about free legal aid. So, you see I am not talking about rights of the arrested person. I am talking about rights of the prisoner. Prisoner who have been languishing in prison and they are not in position to pay court fee, or they are not in position to pay advocate fee due to poverty, they are poor. So, poverty would not be a problem for getting justice. So, constitution of our constitution has provided such a mechanism where poor person can also get justice from the court, and a poor person is also entitled to get justice free of cost. It is constitutional obligation of a state to provide free legal aid to the poor litigants as well as poor prisoners who have committed crime, but they deserve, they are entitled to get this benefit from the constitution, because they must be presumed innocent unless their guilt is proved before the court of law. Unless their guilt is proved, they are innocent. So, because of that presumption, they are also entitled to get free legal aid from the government. And as you might be knowing that Supreme Court for the first time in 1978 in M.H. Hoskot v. State of Maharashtra held that right to free legal aid is a fundamental right, and right to life or liberty would be meaningless for those people who are poor, who are deprived, who are not in position to engage their counsel due to poverty, due to social constraint, they are illiterate. So, in such circumstances, it is the duty of a state to provide free legal aid to its citizen. So, because of this Article 22 and Supreme Court, as I have already highlighted, that in M.H. Hoskot v. State of Maharashtra IR 1978, Supreme Court for the first time recognized right to life as a fundamental right. So, prisoners are also entitled to get free legal aid from the authority concerned, from the superintendent jail. Once they make application to the superintendent jail that they are having BPL card, this is their application, and application along with BPL card may be forwarded to the superintendent jail, and superintendent jail may forward that application to the court concerned, to the authority concerned, that these prisoners who are in jail, they are having this BPL card, they are not in position to engage their counsel. So, I have verified their document, they are entitled to get justice free of cost. So, if their application is forwarded to the court, court is bound to provide legal aid free of cost. So, you see, this is the procedure to get justice from the court free of cost, free legal aid, right to free legal aid. Now, another important aspect of prisoners prison authority, where prison authority can play a significant role in protection of rights of prisoners, that is appeal, jail appeal. So, you just look at your screen, jail appeal. Section 383 CRPC specifically talks about jail appeal, appeal when accused is in jail. So, that appeal is always made by the accused with the help of superintendent jail, and that application is forwarded by superintendent jail under section 303 CRPC. So, suppose where accused has been convicted by the trial court and conviction is confirmed by the trial court, accused is not satisfied with that sentence, he wants to make an appeal against that order. So, and he is in jail. So, the procedure is prescribed in section 383 of the CRPC, that he accused prisoners have right to make an appeal, and that appeal is known as jail appeal. Prisoners, while residing in jail, they can make an application. That application must be duly forwarded by superintendent jail, and that application must be along with the order of the copy the judgment, copy of judgment of the court against which offender is willing to make an appeal. So, application, that is known as appeal memorandum. In technically that application is known as appeal memorandum. Appeal memorandum includes two things: application of the appellant, which appellant has appellant must state entire facts in that application, application written by the applicant, and that application must be along with the order of a copy of the order passed by the competent court. So, with the help of these two documents, jail appeal can be made on behalf of prisoners. This is the provision for jail appeal. Section 383 specifically talks about jail appeal. Now, come to the procedure prescribed under the statute, how free legal aid would be provided by the court. This is the duty. You see, I have written in this way: duty of superintendent jail to provide free legal aid. Free legal aid is provided, as you all might be knowing, that National Legal Service Authority, District Legal Service Authority and State Legal Service Authority. So, there are three tier system in National Legal Service Authority Act 1987. National Legal Services Authority Act 1987 has prescribed three types of system where aggrieved can get justice free of cost: District Legal Service Authority, State Legal Service Authority and National Legal Services Authority. So, these authorities are bound to provide free, means justice free of cost. So, this is another important aspect of free legal aid. Now, come to Article 21 of the Indian Constitution, right to free legal aid. As I said, this right to free legal aid was recognized as a fundamental right by Honorable Supreme Court, in this case in M.H. Horscott vs. State of Maharashtra, AIR 1973. So, this 1978, this is a leading case, because in this case Supreme Court for the first time held that right to free legal aid is a fundamental right, and right to life would be meaningless unless this right is protected by the state. Next is medical aid. As you just see this, you look at your screen, section 24 of Prison Act 1894 talks about examination of prisoners, medical examination of prisoners who are suffering from any acute disease. They are entitled to be examined by medical practitioner, and jail authorities are legally bound to provide this kind of facility to the prisoners who are languishing in jail. So, prisoners are also entitled to get medical treatment from the authority concerned. Section 24 has conferred a right upon the prisoners to get this kind of benefit from the prison authorities. On the other hand, prison authorities are bound to provide medical assistance to the prisoners. And psychological treatment, jail superintendent, they are bound to provide this kind of psychological treatment to those prisoners who are suffering from any mental agony, mental disease. So, they are also entitled to be treated by psychologist, by psychiatric doctor. Right to medical aid is a precious right in the hands of prisoners. So, prisoners are also entitled to get medical aid from the government. Shelter and safe custody, as I said, shelter and safe custody, section 7 of the Prison Act, this section must, Prison Act 1894. It is the duty of superintendent jail to provide shelter and safe custody. So, under section 7 of this statute, superintendent jail, they are under obligation to protect life or limb of the prisoners who are in their custody. So, this is another important right to have safe custody, right to shelter. Model Prison and Manual 2016 talks about accommodation for prisoners. So, this model prison manual, this manual was drafted in the year of 2016 and it talks about accommodation for prisoners. Another important right is right to life. This is most significant right for every human being, and prisoners are also entitled to live with human dignity. How they are entitled? Prisoners are entitled to live with human dignity in prison. I would like to throw some light on statutory provisions as well as judicial pronouncement through which it has been established in India that even prisoners are entitled to get entitled to live with human dignity. So, this provision would make you provide more insight in this. Fair wages and minimum wages. So, I have deliberately referred these two important, fair wage and minimum wage. You students, you all might be aware about one. You look at your screen, you look at this, the Minimum Wages Act 1948. The act itself makes it clear that every employer, whether it is government employer or private employer, is under obligation to provide minimum wages to the workers who are working in their industry or factory or establishment. So, every employer in this country is under obligation to provide minimum wages, otherwise it would be violation of Article 23 of the Indian Constitution, because Article 23 of the Indian Constitution prohibits all kinds of begar, all kinds of forced compulsive labor. No one can be compelled to render his services against his will. So, this kind, you all might be knowing that Article 23 of the Indian Constitution talks about prohibition of trafficking and protection against forced labor, protection against begar. Begar word has been used under Article 23 of the Indian Constitution. Begar literally means involuntary work without payment, where a person is compelled, forced to do a particular act against his desire, against his will, and he is not paid by that work. So, it would be considered as begar. Begar is involuntary work without payment. So, this begar is prohibited under Article 23, and whoever is aggrieved from this kind of begar, he or she can move before the High Court or Supreme Court for getting justice. So, even prison, how Minimum Wages Act 1948 is applicable to the prisoners. Prisoners are also entitled to get minimum wages if jail authorities have got their services. If prisoners, under trial prisoners who have not been convicted and they have been employed in any kind of act, any kind of activities by the jail superintendent. So, in that case prisoners are entitled to get minimum wages. So, jail authority cannot deny to give minimum wages to the prisoners on the ground that prisoners have committed crime, prisoners has breached the law, and as a result of that he himself, they themselves have committed crime, they themselves are criminal. So, criminals are not entitled to get minimum wages. This act, Minimum Wages Act 1944, talks about minimum wages must be paid to the workers working in any establishment. Any establishment includes government establishment as well as private establishment. It is the duty of government employer as well as private employer to provide minimum wages. So, minimum wages is revised from time to time, from year to year, and you might be aware that Manrega, Mahatma Gandhi National Rural Eradication Program Guarantee Act, Narega Act 2005. In that statute, there is clear cut provision that minimum wages must be provided by the state to the workers who have worked under that scheme in Manrega or Narega scheme. So, government is bound. Minimum Wages Act, prisoners are also entitled to get minimum wages, and government jail superintendent is under obligation to provide minimum wages to the prisoners if jail authorities have got their contribution in any kind of activities. So, this kind of observation was made by Supreme Court. You just look at your screen, Gayasuddin versus State of Andhra Pradesh, AIR 1997 Supreme Court. In this case, 97 Supreme Court for the first time categorically held that prisoners are also entitled to get minimum wages from the authority concerned. Authority cannot deny from this from the scope, from the application of this act merely on the ground that prisoners are convicted prisoners, they have been convicted by the court, whether they are convicted or under trial prisoners, they are entitled to get minimum wages provided that rigorous imprisonment must not have been awarded to them. So, in case of rigorous punishment, prisoners they have to perform certain duties free of cost for the benefit of state. So, in that situation where rigorous imprisonment has been awarded by trial court, prisoners are not entitled to get minimum wages. Otherwise, in each and every case under trial prisoners as well as convict prisoners are entitled to get fair wages, minimum wages if they have rendered their services to the authority. So, I think you all might be you all must have understood all these things which I have discussed. Now, another important right which prisoner can avail, that is solitary confinement. You just look at your screen. Sunil Batra case, Sunil Batra was a Delhi administration, as you might be aware about this case, 1980 Supreme Court. This is a very leading case, because Sunil Batra, you see how Sunil Batra mustered his courage to fight against the government. Sunil Batra, he was a prisoner in Tihar jail, and he wrote a letter to a judge of the Supreme Court. In that letter, in his letter, Sunil Batra highlighted the plight of his friends, plight of another prisoner who was also in Tihar jail, and that letter was considered as writ petition. Supreme Court considered that letter which Sunil Batra had written to a judge of Supreme Court, that letter was considered as letter petition in this case, and on the basis of that letter, on the basis of the facts stated in that letter, was inquired by the Supreme Court, and when Supreme Court inquired that allegations were correct. Supreme Court found all the allegations correct, and on the basis of that report, Supreme Court held that Article 5 of UDHR specifically says that every person, every human being has right against inhuman treatment, every person has right against torture. So, torture or inhuman treatment would be violation of human right, and Supreme Court in Sunil Batra case held that where authority has where prison authorities have failed to provide this kind of justice to their inmates of prison, to the prisoners, it would be violation of human right of the prisoners, and prisoners are entitled to get compensation from the government concerned. So, in Sunil Batra case, Supreme Court said that protection against inhuman treatment is fundamental right, and it is integral part of right to life or personal liberty. So, one important thing which you need to remember, that is Sunil Batra case is also important. You just look at your screen, I have highlighted two important statutory provisions, section 29 of Prison Act 1894, section 27 of that Prison Act 1894. Section 27 says that separation of convicts from under trial prisoners. So, it is very obvious reason and it is very logical that convicted prisoners must be separated from under trial prisoners. Under trial prisoners whose guilt has not been established before the court must not be kept along with hardcore criminals, convicted criminals, because if they would be, if under trial prisoners would be kept along with convicted prisoners, they would become hardcore criminal. So, in order to avoid becoming first degree offender to habitual offender, this Prison Act 1894 makes special provision for the separation of under trial prisoners from convicted prisoners, and it is specifically mentioned in section 27 of this act. Section 29 of this act is very important, section 29 Prison Act 1894, which ensure that, you see what section 29 says, that no prisoner shall be kept under solitary confinement. As you all might be aware about section 74 IPC, in Indian Penal Code it is specifically mentioned that any convicted prisoner shall be kept under solitary confinement for not more than 3 months during his entire period of sentence. So, the maximum time limit for solitary confinement is 3 months, generally 90 days or 3 months. So, Supreme Court said that no accused shall be kept in solitary confinement, because it would create problem for the prisoners and they may become they may suffer psychological problem. So, they should not be kept separately, or they should not be kept under solitary confinement. So, you all might be knowing that in Sunil Batra case, Supreme Court already recognized this right, that protection against solitary confinement is also fundamental right under article 21 of the Indian Constitution. If any accused person who has not committed heinous crime, serious crime, if that accused is kept in solitary confinement, he can challenge the order of superintendent of the jail on the ground of this protection against solitary confinement. See, this is all about your model prison policy. What should be the prison, how prison should be reformed, how prison system can be made more effective. So, you see prison, there is a model prison policy, and Mullah committee was set up in 1980, as I have already highlighted this on your screen. Mullah committee 1980 was established under the chairmanship of Justice A. N. Mullah. A. N. Mullah was the chairman of that committee. That committee was on prison reform, how the condition of Indian prison may be improved. So, this Mullah committee made very valuable suggestion for prison reform. I would discuss that recommendation, but before I start that component, I would like to highlight that model prison policy. In model prison policy 2016, it was provided that food, shelter, hygiene, sanitation, these basic amenities, food, shelter, hygiene, sanitation must be provided, must be ensured by the jail authorities, and jail authorities are under constitutional obligation to provide food, to provide shelter to the prisoners, to provide hygiene to the prisoners, to provide sanitation to the prisoners. And third, as you see, third component, fair wages, handcuffing, protection against handcuffing, that is another important right, protection against handcuffing. Now, these important rights which I have highlighted in this with the help of this slide, I believe that you all have understood the things which I have highlighted in this lecture, and now come to another aspect of prisoner's right. As you see fair wages and minimum wages, how prisoners are entitled to get fair wages. Fair wages may be may be determined by the state. It may vary from state to state. It is quite possible that wages remuneration fixed by Punjab government, fixed by Maharashtra government, or wages to the workers prescribed by Kerala government may vary from Bihar or Odisha, because Odisha government, Bihar government may fix this amount of wages as per the financial condition of their states. So, it is not variation is very obvious. So, it may fair wages may vary, but what is important thing is that in each and every case prisoners must be paid fair wages, or prisoners are also entitled to get minimum wages prescribed by the Minimum Wages Act 1948. So, you see how prison can play important role in safeguarding human rights. I have highlighted statutory provisions, I have also highlighted constitutional provisions, constitutional safeguards. Constitution itself being supreme law of the land gives liberty to the prison authorities to provide basic rights, fundamental rights to the prisoners. And finally, Supreme Court being important component of criminal justice system has also recognized certain rights to the prisoners, which were not prisoners who were not having those rights before that judicial pronouncement. Say right to speedy trial, right to free legal aid, right to food, right to shelter, right to medical aid. These rights have been recognized by the Supreme Court, though there is a statute, Prison Act 1894, that statute has already prescribed all these things in that statute, but in spite of that Supreme Court has to intervene in this matter, in this area, and because of that, because of the intervention of Supreme Court, these rights have been duly recognized, and these rights are available to the prisoners. So, this is all about your role of prison in safeguarding human rights. Now, come to prison reform. What things can be done to make prison more effective? By what means, by what method, by which method, by which procedure prison system, Indian prison system can be modified, can be made more effective. So, as you may have some idea about Indian prison system, Prison Act is century old statute 1894, this act was enacted in 1894. Still we have accepted this legislation, this statute still prevails in India, but the main problem which Indian prison system is facing, Indian prisons are facing overcrowding. Overcrowding is a great concern, because every district which has its own prison system, jail system, you might have seen that as per NCRB report, as per government data, government statistics, you might have seen that overcrowd means Indian prisons are facing overcrowding problem, means they in every prison, in every jail, prisoners are more than its legitimate capacity. So, overcrowding. Second important problem which Indian prisons are facing, that is security, safety measures have not been adopted in Indian prison system. Many times it is seen that prisoners, they may be killed by their inmates, by their friends, by their, even in prison are not safe. government statistic, government data also reveals this thing. Third important problem which Indian prison is facing right now, that is lack of infrastructure. Most of the Indian prisons, jail, they do not have CCTV camera in their jail. They do not have computer, they do not have internet access. So, because of in digital era, Indian prison system is lacking of all these infrastructures, means in many of most, even Tihar jail is also facing such kind of problem, and many district jails, they do not have CCTV cameras, they do not have computers, they do not have digital access. So, because of these lacuna, because of these demerits, our Indian means our prison system is facing so many problems. So, now time has come to look into the matter, and unless Indian prison system is equipped with this kind of mechanism, technology, CCTV camera must be installed in each and every prison, so that internal activities or activities of the prisoners may be thoroughly watched by the jails, by the superintendent jail, and the behavior of superintendent jail or the behavior of jail staff can also be supervised with the help of CCTV camera, with the help of digital devices. So, this is another area where we need to modify, we need to rectify. Another important another important issue which is always in question before prison authorities, that is insufficient staff or well trained staff, means jail, neither jail superintendent nor working, means their staff, meaning to say that those warden or constable who are working in prison, they are neither equipped with digital equipment or not they are trained, they are not aware about modern things, they are not aware about. So, that is why they commit many times they commit crime in the prison also. So, awareness is necessary, they must be equipped with digital device, so that things can be improved. So, and health issues like vulgarity or corruption, many times it is seen that jail superintendent and their staff, they are closely connected with hardcore criminals, and when search is made in jail, so you might have seen that with the help of newspaper, that when a particular jail was visited by that authority, by superior authority, many mobile or mobile cell phone were recovered from the prisoners. So, how is it possible that prisoners who are in jail, they get mobile phone in prison? Mobile phones are not allowed in spite of this, they use this method. Prisoners, hardcore criminals, they enjoy their life even in prison. So, this thing is also modified, needs to be rectified, modified by the statute. So, without having good statute and without having effective mechanism, we will not be in position to remove all these problems. So, I think that by doing all these exercise, we can make our prison system more effective, more sensitive. So, now time has come to sensitize those government employees who are working in prison, so that health issues, their security or safety issues may also be modified or may also be improved. So, with this I think I have covered each and every aspect of prison system, how Prison Act 1894 is helpful in protecting, safeguarding rights of prisoners. With this I would like to conclude my lecture, and thank you Thank you all.